Hi guys, welcome back to Batok with Ola. This is Mujala Olua and I'm super thrilled to be here once again. Today I want to take you through a draft video on how to draft a pre-action notice. We've done a video on pre-action notice on the channel probably a year or 2 years ago. Recording this video March 2024. So for you to place the time that we did the video, the actual video where we discussed it at length. In the description box to that video, I also added a blog post that I made about 6-7 years ago, maybe 5 years ago or 6 years ago, on my personal blog on pre-action notices. Pre-action notices are so fundamental. They are a procedural defense that a defendant in a civil suit can come under to say that, oh, courts do not hear the claimant because they have not fulfilled so and so. The law stipulates that they should do so and so before they come to court or before they drag us to court, and they have not done it. Therefore, do not listen to them. Do not adjudicate this matter. They make a good case. It could be a sustained objection, which could slow down the case or essentially throw it out of court temporarily. So pre-action notices are very important. Of course, there are some pre-action requirements that are just commonplace and standard, like exploring ADR before going to litigation. But furthermore, if you're about to sue, especially a corporate body with perpetual succession, maybe a government agency or a public company, it's important for you to check their enabling laws, that is, their establishing laws, to find out if there's any stipulation regarding pre-action notices. That is, if their establishing law has said, before you drag us to court, you must have done this or that. For pre-action notice, there will be a stipulation that you must have served us a notice that you intend to take legal steps to file a suit against us for a period of, you must have given us a period of time, notified us over a period of time. Some say maybe 1 month or 30 days. So it's important, if you're trying to sue an organization, you have to check their establishing laws to find out if there's a requirement for pre-action notice or any other pre-action requirement. So if there's a requirement, then you draft the notice and you serve it on them, wait for the time to lapse, follow all the things stated in the pre-action notice. When you read the blog post, I cited a case whereby the company law, the establishing law, had said that in the pre-action notice you have to tell us who the claimant is, where they live, the particulars of the claim that you intend to file, several other requirements. So you have to follow those things. So this is a sample draft to give you a general idea of how to draft a pre-action notice. But if the particular laws of the establishment that you want to sue requires further details, then you know that you need to add them into your pre-action notice. But this is just a general sample. Like I say, for draft videos, you do not have to copy them word for word. Just make sure that you adapt them to your own situation. So the pre-action notice is drafted on the law firm's letterhead. You can see here I have O.M. Livingstones and Co., which is my law firm, Barrister Solicitors and Notary Public, number 1 FH Road, Lagos. House of Livingstones at gmail.com and my phone number. So you have to include the means of correspondence by which they can get back to you as well if they are replying your notice. Because while a pre-action notice precedes litigation, it does not necessarily have to result in litigation. So they could call you to resolve the matter or to explore ADR, as the case may be. So I have our ref, that's my law firm's reference, the referencing system, and I have dated it 11th March 2024. Then I'm addressing it to the Director General, Nigerian Postal Services, 9 Post Headquarters, Muhammadu Buhari Way, Area 11, Garki, Abuja. This is just a sample, so I haven't checked the Nigerian Postal Services establishing laws to see what they have to say about pre-action notice. I'm just giving you a sample. because in most cases, government agencies and establishments and public companies are the ones that have pre-action notices. In most cases, but not all the time. So just check and confirm, be sure before you head to court. Then, dear sir, it could be dear ma, Then pre-action notice, that's the title. We have the heading, my address, the date, reference, address of the addressee, and salutation, then pre-action notice. Remember your letter writing from secondary school. Then the opening paragraph. This is always important for letters written or drafted by law firms and lawyers. We are solicitors to Dr. Mobonike Ayuade Josephine, hereinafter referred to as our client and on whose instructions we write to you. Our client is a medical doctor of many years standing who works as a consultant at the General Hospital Area 1, Abuja. It is our brief that on the 1st of February 2024, as our client drove to work on unusual routes, having been green-lit by the traffic light in our direction, your mail truck with registration number ABJ 422WLR, driven by your staff identified as Mr. Dawaki George, rammed dangerously into our client from the rear that fateful morning. So you can see you have to be particular about the details. It is like a mini statement of claim, except you're not addressing it to the court, you're addressing it to the prospective defendant. So it could even be more detailed than this. This is just a sample. Your staff drove the mail truck recklessly, ignoring the red light stop in its direction, thus causing this avoidable accident, just trying to lay a foundation for negligence. Then this accident caused serious damage to our client's car and serious head and neck injuries to our client. Our client is still receiving medical care at the time of writing this letter and has spent almost ₦1 million on medical care alone. Not to mention the implications and expenses of not being able to work or care for our family since the incidents. All efforts to reach your company for any fruitful dialogue around this issue has proved abortive. Our client is therefore prepared to institute legal action for negligence against your company. So now, the explanation is to establish negligence. For negligence, to establish negligence, you have to prove 4 ingredients were you to go to court. 1, that there was a duty of care owed by the defendant to the claimant. 2, that duty was breached. 3, that a damage or injury was caused, and the injury or the damage was as a result of the negligent act of the defendant. So if you prove those 4 things, the court may hold for you for a claim of negligence against any defendant. So this is what you've tried to prove by your explanation. And from the tone of this letter, you can tell that this is not the first contact with this company. And that is why you don't see things like saying, oh, we have attached the proof of our medical care, we have attached pictures of the injury or whatnot. So at this stage, the company already knows what's going on. They are aware. That's why you'd see that I mentioned that they have refused to do the needful. So it could be that we've been in talks and they've just refused to take responsibility, or what they've proposed is not acceptable. So if this is not the case, you have to add proof to your own pre-action notice, just to substantiate. Remember, it is like a mini claim, except you're claiming directly from the defendant, asking them, notifying them that you will go to court to claim those things. So if they want to play ball, if they do not want litigation, they would come to the table with you, discuss, and probably agree to something that you would also agree to, or something that is acceptable to you. They would make an offer, there will be acceptance and all of that, and it might be settled out of court. But in the event that they do not, you will still go to court. So this is just a precursor to litigation. So it's no jokes. You have to come serious and put a tight prospective claim together in your pre-action notice. So our client is therefore prepared to institute legal action for negligence. You must include what you intend to do, and that this is a pre-action notice to them. Of course, it might be implied even if you don't say that it's a pre-action notice, but it's better to just spell it out So when you're filing your claims in court, you can file this alongside to prove to the court that you have fulfilled the requirements for a pre-action notice to the defendant establishment. As soon as the 30-day pre-action notice period stipulated by your establishment law is expired, this letter is in compliance with and serves as pre-action notice to your establishment for all intents and purposes. Please be informed that our client is prepared to explore all legal remedies available to her to get redress in this matter. We expect the establishment to do the needful in the interest of justice, in the absence of which we shall meet in court. Then your closing, yours faithfully, the signed Mujolalua Livingstone's partner, OM Livingstones and Co. So that's essentially what a pre-action notice looks like. You prepare it and serve it on the prospective defendant, and be sure to get an acknowledgement copy. So that's all I have for you in this video. I will see you in my very next video. Don't forget to subscribe and bring your friend along to Bar Talk with Ola. Toodles.